mortgage pass-through certificate holders. Wells Fargo is the appellee, is the trustee of the pass-through certificate holders, and they are acting through CW Asset Management, which is a special servicer for the loan. Wells Fargo, through CW, brought an action for foreclosure by filing a verified complaint verified by an employee of CW by the name of Lisa Trolson, and they also filed a motion to appoint a receiver at the same time. Fairfield Lakes then filed a motion to dismiss for lack of subject matter jurisdiction and noticed it to be heard at the same time that the hearing to appoint the receiver was to be heard.
Counsel, having litigated cases, the procedure for noticing a matter for hearing varies by circuits. What's the procedure for noticing a matter for hearing in your circuit?
When a hearing is set, there's already a time allotted for it. If there's enough time for another hearing, we can set a hearing on a motion that's already been filed for the same time.
Must you contact the judge's chambers to do that?
Yes, Your Honor.
Was that done in this case?
Yes, Your Honor. At the hearing, the lower court erroneously noted that Fairfield Lakes' motion to dismiss had not been set for hearing. The court mentioned that there was a motion to dismiss set, but didn't acknowledge that the notice for hearing was filed and was in the court papers. That was just simply an oversight by the court because it was noticed for hearing.
The trial court did not hear your motion to dismiss at the hearing, did it?
It heard elements of it, Your Honor, because one of the things that we were addressing.
Did the trial court decline to rule on your motion to dismiss at the hearing?
Well, that's kind of a tough question because it didn't rule per se on the motion to dismiss, but it did. The motion to dismiss alleged that there was lack of subject matter jurisdiction. The court did find that, and one of the errors that we allege is that the court used the wrong standard when it found that it found sufficient basic subject matter jurisdiction to go ahead, and then it went on to hear the motion to appoint the receiver. So, in essence,
how many days prior to the scheduled date of the motion for hearing was the notice of hearing served on the opposing counsel?
I believe it was 5 days in advance. That's when the motion was filed.
Was it served in person or was it served via mail?
Via mail and facsimile.
Isn't the other side given 5 days mail time?
Yes, Your Honor.
Would you consider that a reasonable length of time in terms of serving the motion to dismiss on the opposing side?
Yes, Your Honor. Ultimately, the court, as I said, did look into the matter of subject matter jurisdiction, which was raised, found that there was basic subject matter jurisdiction, which part of our argument is that you can't have just a little subject matter jurisdiction. Either you do or you don't.
Explain to me why there wasn't subject matter jurisdiction here. You had a piece of property in Escambia County. It was a mortgage foreclosure action, which is typically within the jurisdiction of the circuit court. The plaintiff was the holder of the mortgage, and the defendant was the obligee, or obligor, whichever it is. I mean, I don't understand how.
Well, Your Honor, one of the issues was who really is the holder and owner of the note.
Your client acknowledged when they assumed the mortgage that it was Wells Fargo.
Well,
that's the plaintiff.
That's true, Your Honor, but by signing the acknowledgement of the loan assumption paperwork, all that did was establish the obligations between the two parties. It didn't necessarily establish the validity of the owner and holder of the note. This has been quite a convoluted transaction. The note was first in the.
Well, let me stop you so you don't have to go through the transaction. If the assumption and the acknowledgement isn't enough in your view, I mean, again, we're on a motion to dismiss in any sense. So you've got the allegations in the complaint and anything attached to it, and the attachments control over any conflicting allegations in the complaint. So didn't the attachment set forth this convoluted passing around of the note? I mean, at the end of the day, I guess where I'm confused when I read the complaint and the attachments, it sure seems to lead a trail right to Wells Fargo as the holder. Why is that mistaken?
Well, part of our allegation of lack of subject matter jurisdiction, Your Honor, is that the lawsuit was brought by CW Asset Management Corporation as a special servicer acting on behalf of Wells Fargo, who is the trustee of the mortgage pass-through entity that is the actual owner and holder of the note. So it was our allegation that CW didn't have any authority to bring because they weren't the party in interest and weren't the owner and holder of the note.
Basically, you're alleging that CW did not have standing
Yes,
to bring
sir.
the lawsuit.
And
Is standing a lack of subject matter jurisdiction issue?
we think it is, Your Honor, because standing is a threshold issue. The court has to look at standing to see if it even has jurisdiction. You know, it's kind of a catch-22, but if you don't have standing, you can't have subject matter jurisdiction, and it's a threshold issue, almost as if it's an element or a component of jurisdiction.
There was no allegation that CW was seeking to foreclose this property or foreclose this mortgage on its own behalf. It was acting as an agent of Wells Fargo, the person who was alleged to be the plaintiff, wasn't it?
Right, Your Honor. But in order to foreclose a mortgage, the owner and holder of the note has to be the one to do it, or someone acting on the authority of the owner and holder of the note.
Why isn't that what we have?
Well, there's nothing in the pleadings. Normally, there's an agreement in these mortgage cases for the special servicer who gets involved when there's a troubled asset. There's an agreement that outlines their authority to do something, to act on behalf of the underlying entity, and gives them their duties and gives them their authority to do it. There's nothing in the record that provides CW the authority to do this.
But why would that, I guess, maybe back to Judge Lewis's question, why does that become a subject matter jurisdiction problem rather than a pleading problem? I mean, maybe you're right. Maybe if an agent is bringing this action on behalf of the real party in interest, there needs to at least be an allegation in the complaint that they have the authority, and perhaps even better, an attachment to the complaint showing their authority. But at the end of the day, you have the mortgage holder suing the person that owes them.
Well, it may eventually get around to that, Your Honor, in all honesty, but it's not properly pled that way. And
Let's assume that it's not properly pled as part of the complaint. What if the exhibits attached to the complaint show standing? Would that be sufficient?
Perhaps that would, Your Honor, but that's not what happened in this case, because there's no documents attached to the complaint that give CW the authority to prosecute anything on behalf of Wells Fargo. Even further, there's nothing in the documents that give Wells Fargo, who's the trustee of the actual holder of the note, there's nothing that gives them any authority to act as the trustee. There's no trustee agreements. There's nothing of that nature. So not only do we not have the proper person bringing the lawsuit, but the attachments that would perhaps give them authority are not exhibits to the complaint, and we can't presume that those exist if they're not attached. If they're not attached, they're not there.
How would this be any different if Wells Fargo or Wells Fargo as trustee or whoever the records show actually holds this note? How would that be any different if they just filed a two-page lawsuit that says we're the mortgage holders, they're the ones who owe us the money, they haven't paid, therefore we want you to foreclose, and didn't attach anything? I mean, wouldn't you have a situation where the court's jurisdiction has been properly invoked, but perhaps there's a pleading deficiency that would be ripe for a motion to dismiss with leave to amend?
That's a good point, Your Honor, and that would be the case if that were the situation.
Why is that not the situation?
Because in this case, they did plead, hey, it's our loan, we're the holder of the note, and therefore we can sue you. But they haven't, CW has said that they're the entity that's acting on behalf of a trustee who's acting on behalf of the owner and holder. So they've alleged that all that, they should have to have the documents attached that substantiate that. So the three issues that we brought to the court all kind of go along with standing. And that was, our argument was, prior to the judge ever reaching the issue of the receiver and issuing his order, which we allege he did in error, the issues that we just discussed. The second issue is that a lot of the documents are, along with CW's complaint, it's verified by an employee of CW. When you verify a complaint, as you do in an affidavit, you're saying you have personal knowledge of the events that you're alleging. The signer of this note, Cynthia Trolson, doesn't even know the basic facts about it. She's never spoken to Wells Fargo, and upon questioning, didn't know certain dates, why dates were what dates. Documents were signed in different orders when it was transferred from one entity to another and then to another all on the same day. She couldn't say what order they were done in.
And this may be a silly question because I've never done this work, is there a requirement that a mortgage foreclosure complaint be verified?
In a commercial setting, you can interpret the rule to say no because the Florida Rule of Civil Procedure doesn't specifically say a commercial. But if you choose to verify a complaint, and that's what's different, if it's verified, you've got to know what you've said that you've put down in there.
Well, she signs the verification. She has made this affidavit either upon her personal knowledge of the facts involved, which you contend her deposition shows was not the case, or based upon the books and records customarily kept and maintained by the plaintiff, which we have to assume is Wells Fargo. So why, assuming this verification is required, why is that not enough?
Well, she never made herself acquainted with the reasons because under questioning she couldn't explain why these dates were the dates that they were, or what order these transactions were. And if the entities had transferred the loan in the note in the wrong order, then we wouldn't have the proper person holding the note that's trying to act through these other entities in order to foreclose the property.
Let's assume that the only issue or problem with the complaint was that it did not allege that CW had standing to bring the action on behalf of Wells Fargo. The proper remedy have been to dismiss the complaint or abate the action to allow plaintiff to amend to allege standing.
Well, we would argue that it would be to dismiss the complaint, but there probably would be leave to just amend it and abate the action until it was properly proven. I just wanted to mention one more thing as my time is running short. The judge in this case the judge granted the motion to appoint the receiver. The appellee sent a motion to us and to the judge. We sent an email back saying we objected. We sent a letter simultaneously to the judge since the order had already been sent to the judge saying we don't agree with this order. Please allow us to respond. The judge never responded to us and 2 weeks later granted his...
Isn't that last thing you said pretty significant? I mean, he didn't do what sometimes judges do, sign it notwithstanding an objection letter sitting there. He waited 2 weeks. I mean, you had 2 weeks to send him what you would want him to sign.
Yes, Your Honor, that's true, but we waited for him to give us permission to send something in. Sometimes it's a delicate matter whether you prompt the judge as something's due or not, and so we elected to wait, as was our nature to...
I guess my point is you would at least agree that this is maybe not as egregious of a situation as some of those other cases.
Yes, Your Honor, and Perlow and Strand, and some of these are distinguished because it was 2 weeks, it wasn't 2 hours, but he did adopt verbatim about an 8-page order that included such things as allowing the appellee to completely waive any acts of negligence against them, which would only be a contractual thing, and I can't imagine a judge would do that. That kind of indicates that he didn't take his own independent thought and time to go over the order. He didn't strike anything, change anything, he adopted it.
Counsel, you're well into your rebuttal time.
Yes, you are.
I will extend your rebuttal time by an additional minute. We will also extend the appellee's argument by an additional minute as well. Thank you.
Okay, thank you, Your Honor.
May it please the Court, Christine Graves on behalf of the appellee, Wells Fargo. With me at council table is Hal Leonard. I'd like to begin by putting this case in context because there's a lot of issues being thrown around. The only order before this court that is being appealed is an order appointing a receiver. That order is based on the evidence presented by Wells Fargo below, showing that a receiver was necessary to protect the property while the foreclosure proceeding was pending. Wells Fargo filed its complaint in April of 2010. Appellants answered the complaint on June 8th of 2010. Answered in affirmative defenses with no standing, no lack of capacity raised in that answer. Wells Fargo noticed the hearing on its motion to appoint a receiver
Is
in
standing
August.
an affirmative defense?
Standing is an affirmative defense. That's well established. In August of 2010, Wells Fargo noticed the hearing on its motion to appoint a receiver, and then not until October, 4 months after it had filed its answer in affirmative defenses, it files a motion to dismiss, which is precluded by the rules after you've already filed an answer, and raised standing and lack of capacity for the very first time. And it did this days before the hearing on the motion to appoint a receiver. Trial counsel received that notice the day before the hearing, and the court made explicitly clear in the hearing it was not considering that motion to dismiss.
Well,
so
let
the
me ask
court.
you this. If the basis they brought up in that motion was truly a subject matter jurisdiction deficiency, wouldn't we be able to review, despite the trial court's refusal or declining to hear the motion to dismiss, wouldn't we be able to consider in evaluating the order before us whether the trial court even had subject matter jurisdiction?
Absolutely. You can raise subject matter jurisdiction at any time, but that's a critical distinction here. Standing has no relation to subject matter jurisdictions. The cases are clear. Standing and lack of capacity are affirmative defenses that need to be raised in an answer. If they're not raised in an answer, they are waived. Subject matter jurisdiction, on the other hand, is the court's ability to hear a class of cases. So it can act on a class of cases, not whether one particular party has standing. Section 26012 of the Florida statutes provides circuit courts with the exclusive jurisdiction over foreclosures as long as the property to be foreclosed upon is located in that circuit.
Counsel, you indicated that we're here on the order of granting receiver and not. I assumed you were going down the road of making an argument that, look, this is not the foreclosure. I'm going to ask you, are you basically saying that defenses such as those that may have been other than those waived, such as affirmative defenses, but are you trying to make the point that as far as the merits go on the foreclosure, that can be debated later?
Yes, my first point is that the only issue before this court is the appointment of a receiver. The trial court never considered standing, lack of capacity, any of this. It would be considered in the trial court. Of course, going back to the trial court, and if this court for some reason believed that it could consider it here, which I would submit that it absolutely can't because there's no ruling from the trial court below, the allegation of standing as an affirmative defense was raised 4 months after their answer, which did not raise it. And if we get into the issue of standing, counsel for appellant indicated that we would have to file the agreement with the complaint. That's not the case. The rules do not require a bank or a servicing agent suing on a real party in interest, suing on behalf of the real party in interest to file the agreement with the complaint. You attach only necessary pleadings, which in this case would be the pleadings to prove that that this was a foreclosure action, that it was defaulted, the need for a receiver, and that sort of materials. There is a
let me ask you this, because I agree with you that a agent acting on behalf of the real party in interest, the ultimate thing to prove foreclosure has nothing to do with this. But when one picks up this complaint and starts reading it, Wells Fargo Bank as trustee, okay, that all makes sense. This all makes sense. Acting by and through CW Capital Management. First thing I did when I was trying to figure out who is this,
right.
And there's not a single allegation in the complaint telling us, well, maybe there is. The one allegation I saw is talking about where CW asked them for the money and they didn't get it.
Right.
But there's nothing that says, CW is the authorized agent, blah, blah, blah. Couldn't this complaint have been better pled on that issue?
Anything could be better pled, but I would say this one is completely sufficient because in there it recognized in the complaint and alleged that it was a special servicing agent for Wells Fargo and that it was suing on its behalf. What you would do if you were looking through a complaint, and this pooling services agreement, which gives the special servicing agent authorization to sue on behalf of the bank, is 400 pages long. If you had an affirmative defense, you look at the complaint, you're saying, who is this CW asset? I have no idea. You raise it in your affirmative defense. Lack of standing. Who is this person? Ask us in discovery for show me why you have standing. And we produce this pooling services agreement, and we go on from there. The inner judgment, partial judgment on the affirmative defense of lack of standing. It's done. But the rules, I reiterate the rules. 1.130 make clear, 1.130 make clear. 1.030 make clear that you do not attach unnecessary papers to your pleadings as exhibits that are incorporated in the complaint. And what we attached was a stack this big of the history behind these loan transfers and transactions, which showed that this indeed was a proper foreclosure proceeding. The property was located in the jurisdiction of the circuit. Therefore, the court had subject matter jurisdiction over the case.
They made a suggestion, and again, I understand your threshold argument that none of this is before us, and it was waived. I understand all that. But for curiosity's sake, if nothing else, the question I asked them, is there a requirement that a foreclosure complaint be verified?
No.
And if so, is this verification an unnecessary document?
The rules to look at would be of course, I had them all in my head before, but 1.030, I believe, and 1.110 talk about what you're required to put in your complaint, or what complaints are supposed to be verified. 1.110 expressly requires a residential mortgage complaint, a foreclosure on a residential mortgage, to be verified. Rule 1.030 specifically says that no complaint other than those expressly recognized in these rules need to be verified. So no, a commercial mortgage foreclosure action complaint does not need to be verified. The fact that it was, at most, would be harmless error because it does not need to be verified. And also, their arguments on that point fail for other reasons as well. First, their entire argument on that point of the verified complaint is based on a deposition testimony that is nowhere in the record. Lisa Trolson's deposition testimony was not presented to the trial court. It is not in the trial court's record below. They attached it to an appendix up here, but it was never in the trial court below. So their entire argument is relying on evidence that's not in the record.
Were there any documents filed in opposition to your motion to appoint a receiver?
No. And they have not challenged the court's order appointing the receiver based on the evidence the court considered and finding that, yes, this property needs to be protected.
Do you think this is a meritless claim?
Which one?
Their defense.
Absolutely. Every single one.
Have you moved for sanctions under 57105?
Your Honor, if I was here,
I'm beginning to hear that drift.
I absolutely agree, and this court can do that sua sponte. If I had been here at the beginning of the case, I might have done that. But
your argument now is it's a meritless complaint. A meritless appeal.
A meritless appeal. The only thing being appealed is the order appointing a receiver, which deals with, of course, the evidence presented below. Does a receiver need to be appointed to protect this property pending this action? The court found yes. They nowhere dispute that. Nowhere raise challenge the evidence.
Counsel, assuming you are correct, the trial court did not rule on the appellant's motion to dismiss. On remand of this matter, is the appellant foreclosed from re-noticing its motion to dismiss for hearing before the trial court? Does the order granting the motion for appointment have any effect on their motion to dismiss?
No. They have never noticed that motion for hearing. It would have to first be decided by the trial court. And, of course, when we get there, we would raise all of these arguments about how they did not plead it properly, why it's invalid.
Can they re-notice the matter for hearing before the trial court?
Yes.
They can re-notice the matter on the affirmative defense of standing, and then they can lose.
That's exactly right. So they're not foreclosed from noticing it because they never did.
But it has no merit because it's waived.
Right, and that's what we would tell the trial court. But here, they've raised all of these arguments on appeal that the trial court has never considered and never ruled on. And when it ruled on subject matter jurisdiction, which they attempt to try to equate with standing, the court only found subject matter jurisdiction based on what subject matter jurisdiction actually is, which is the ability to hear a class of cases, which is the exclusive jurisdiction to hear a foreclosure, has absolutely nothing to do with standing. The cases are very clear. Standing is a waivable affirmative defense. Subject matter jurisdiction is the authority to hear a class of cases.
So your response to their argument that CW Capital Asset Management is somehow involved in the bringing of this case on behalf of Wells Fargo would be no different if the complaint was filed by Disney World versus them. And, you know, Disney World doesn't hold the loan here. But that does not mean, I guess, under your argument, that the trial court doesn't have jurisdiction over that.
Absolutely not. If Disney World filed a complaint to foreclose this property based on these loans and had absolutely nothing to do with those loans, then they would raise an affirmative defense of lack of standing. And then we would have to argue that, present evidence on it, and argue that. The reason that CW Assets did it is very, very routine in the mortgage industry. They have a pooling service agreement which allows them to do everything on their behalf to proceed to a foreclosure when when loans are being defaulted on.
Counsel, again, assuming you are correct, the trial court did not rule on the appellant's motion to dismiss, meaning that motion is still currently pending at the trial court.
Yes.
And all the arguments you have made, compelling arguments, as to why the trial court should deny that motion to dismiss on appeal, or why it was not properly before the trial court, shouldn't those arguments be made before the trial court on remand of the matter for the trial court to make a determination on?
Yes.
And will you be foreclosed from filing a motion regarding the sanctions at the trial court regarding the filing of the motion?
Yes, they can renotice their hearing. That motion to dismiss is still pending below. Whether I could file a motions for sanctions against them would have nothing to do with this appeal. If I chose to file a 57-105 motion against them, it would be because they filed an answer without raising their affirmative defense, and then they filed a post-answer motion to dismiss.
And that would be a matter for the trial court to determine.
That would be trial court, and that would have nothing to do with this appeal having foreclosed them from raising any of these arguments in the trial court. It would be completely separate. They would actually notice their motion to dismiss. We would have a hearing. We would probably, we would file our response, which we never got a chance to do since we got it the day before. And we would point out to the court that this is waived, completely waived. And in all events is wrong because here's the pooling services agreement that they never asked us for, which they can, and they would have it, and we would all show the servicing agent has the authority to sue on behalf of Wells Fargo.
This is an appeal of a non-final order.
Yes, it's an authorized non-final appeal.
And so all of these potentially, if they had a meritorious basis to have this complaint dismissed, trial court couldn't have acted on that while we had the case because it would have undermined our ability to review the non-final order.
Well, that's sort of right.
Okay.
What the trial court can proceed.
That's better than I usually do.
Yeah. The trial court can proceed with the case. It can go through the foreclosure proceedings. It could have heard this motion to dismiss because it has nothing to do with the appointment of a receiver. The only thing the trial court can't do is enter a final judgment while the appeal is pending. But this appointment of a receiver is a separate non-final order limited in this court to this authorized non-final order.
I think you've convinced me I'm completely right then because if the trial court would have granted that motion, then it would have essentially pulled the rug out from under the appointment of a receiver, and thus, I think we're arguing theoretically.
Yeah.
I mean, if they dismiss the case below, there's no case, there's no basis, nothing to have a receiver enter.
You can dismiss the case below and then just not enter a final judgment until this court rules, which is, we've had this case and another case that I've had where they had a cert petition going up on discovery, went on forever. It's in the Supreme Court now, and they actually got a jury verdict. Court can't enter a final judgment.
Let me ask one other question. I assume this is correct, that the appeal of the order appointing receiver didn't have the effect of staying that. A receiver was appointed and is taking care of the property.
No motion for stay was sought. You could have. I doubt the trial court would grant it because it's separate. The purpose of a receiver is solely to protect the property, to make sure that property owners are giving us their rents and any interest or any income earned on that property instead of keeping it. So the only thing the judge found is listen to our evidence and concluded that, yes, this property needs to be protected. This standing and everything else is collateral to that.
So I guess to play devil's advocate to Judge Thomas's concerns about, the merit of this appeal, the bank, Wells Fargo, is really not, other than having to expend attorney's fees in defending the appeal, is really not out anything, because you could have proceeded all the way up to final judgment while this case was up here, and the property is being managed while it's up here.
The property was being managed. We could have continued to proceed with the action. There would have been a motion to dismiss pending, so it would have been their move first to get that motion heard and decided. And yes, we could proceed. So in fairness, we are out plenty of time and money, but from this improper appeal. But they could have continued below. There was no stay. The receiver is solely to protect the property.
Thank you, Counselor.
May it please the Court?
Counsel, I'm a little bit concerned concerning the statement that a motion to dismiss was filed by you after the answer was filed in this case. Is that correct?
Yes, Your Honor, I believe so.
Wouldn't a motion for judgment on a pleading from a procedural point of view have been the appropriate motion to file with the trial court?
That's possible, Your Honor, but in the fact that we were addressing subject matter jurisdiction, we thought we could raise that any time through a motion.
And let's assume for the sake of argument that standing is an affirmative defense rather than going to subject matter jurisdiction, then shouldn't that matter have been raised pursuant to a motion to judgment on the pleadings as opposed to...
If that were accurate, Your Honor. But it's our position that standing does not necessarily have to be raised by affirmative defense. And the reason is, and I know I can't bring up any new case law that we haven't discussed, but there's a Supreme Court case and there's cases been discussed in the second DCA sister court that says it can't be raised for the first time on appeal. It has to be raised with the trial court, but not necessarily by affirmative defense. And what the courts in that said was it wasn't how it was raised necessarily, it was that it was raised at the trial court level. So by filing our motion to dismiss and by raising it in our initial argument with the court, we alleged it and brought that up. So it's not being brought for the first time. It's not waived because it's brought up by other means.
But shouldn't we just let the trial court sort that out? Shouldn't we just focus ourselves on this order appointing receiver and see if there's any basis to reverse it and let y'all fight about standing and when it was raised?
Yes, Your Honor, that can be done. But the issue on this order is not whether there was merit to grant the motion for receiver, but how the order was done. That's our argument.
Your first issue raised on appeal involves standing. Is that correct?
Yes, Your Honor. And we're saying that the court never should have reached the issue of should a receiver be appointed.
But assuming the trial court did not rule on your motion to dismiss, then the issue of standing would not be properly before this court.
Well, he did rule, Your Honor. He said he found basic subject matter jurisdiction.
Let's assume for the sake of argument
that
counsel for the appellee is correct. The trial court did not rule on your motion to dismiss. Then would the issue of standing be properly before this court?
No, Your Honor.
Thank you, counsel. This concludes our business for the day.